In 1832, the state of Georgia held a lottery. The prizes were farms, 160 acres each, surveyed, numbered, and drawn out of a wheel in front of witnesses, and the winners were told to go and take possession. Every one of those lots was somebody's land at the time. The people who held them were still living on them, still farming them, and would go on living on them for another 6 years. This is the story of the largest transfer of real estate in American history, told the way the people who organized it saw it, which is to say, as a property transaction. Here is the ground we cover: what the land was worth and who valued it, what was actually paid for it to whom and under what signature, who ended up holding the money, and the part almost nobody knows, which is that the cost of moving the people off it was charged against the price paid for it, so that the sellers funded their own removal out of the purchase money. Start with the lottery, because it is the fact that reorders everything else. Georgia had run land lotteries before. It was the state's standard method of distributing public land, and it was genuinely popular, because unlike an auction, it did not favor men with capital. Any qualified white male resident could enter for a small fee, and a landless man could walk away with a farm. The sixth of those lotteries, drawn from 1832, disposed of the Cherokee Nation. The surveyors went in and divided the territory into two kinds of parcel: land lots of 160 acres for farming, and gold lots of 40 acres in the districts where gold had been found. Something over 18,000 land lots and around 35,000 gold lots went into the draw. The gold is why the timing is what it is. In 1829, a deposit was found in the North Georgia hills, in country that was Cherokee under a federal treaty, and within a year there were thousands of men digging in it. This is usually filed under the Georgia Gold Rush and treated as color. It is not color. It is the moment the land stopped being agricultural acreage of ordinary value and became something a state legislature was prepared to break a federal treaty to reach. So by the middle of 1833, there were white Georgians holding lottery certificates for farms that were occupied by Cherokee families, and a state government that regarded those certificates as good title. What happens over the following 5 years is, in one reading, simply the process of making the certificates true. And every step of it went through an institution. The Congress of the United States passed an act. The Supreme Court heard the case twice and gave a judgment. A treaty was signed, submitted to the Senate and ratified. A commission was appointed to hear claims for property, and it sat, and it heard them, and it made awards, and money was paid out. So here is the question this whole story comes down to, and put your answer in the comments before you hear mine. If a thing is taken by an act of Congress, a ratified treaty, a state law, and a claims commission that pays out on the losses, is it still a taking? Or is that just what buying looks like, when only one side is allowed to set the price? See whether you still think the same thing by the end. And before we go any further, hold on to one fact about that gold, because it is the detail that tells you the federal government was not a reluctant bystander here. In 1835, Congress authorized a branch mint at Dalonga, in the middle of the ground that had just been drawn in the lottery. It opened in 1838, the same year the removal happened, and it struck gold coin of the United States out of Georgia gold for the next 23 years. The government did not merely permit the transfer, it built a facility to process the output. To answer it, you have to know what was actually there, and this is where most tellings go wrong, because the picture in most people's heads is of a wilderness with camps in it. The Cherokee Nation in 1830 was a settled agricultural republic with a written constitution, a capital, a Supreme Court, a bilingual newspaper, and a road network it charged tolls on. The Constitution was adopted in 1827 at New Echota, and it was modeled closely on the federal one. An executive, a bicameral legislature, a judiciary, elections. The writing system had been completed by Sequoia a few years earlier, a syllabary of 86 characters that could be learned in weeks rather than years, and literacy in Cherokee spread through the nation faster than literacy in English had spread through the states around it. The Cherokee Phoenix began printing in 1828, in 2 columns, Cherokee and English, on a press bought with nation funds. Consider what that means as an asset register. A nation that prints a newspaper has a press, a building, type, and an editor on salary, and every one of those is property that appears later in a valuation schedule. Then there were the farms. Cherokee households in the 1820s were running the same mixed agriculture as their white neighbors, on the same crops, with the same tools, and in the wealthier households on the same terms. The elite of the nation held plantations and, uncomfortably for every romantic version of this story, held enslaved people to work them. Somewhere between 1,000 and 2,000 enslaved people were owned within the Cherokee Nation, and most of them were taken west in the removal, along with everything else that was counted as property. That is not a detail to skate past, and it is not there to complicate the moral arithmetic. It is there because it is the single clearest proof of the thesis. The Cherokee Nation was a property-holding society operating by the property rules of the American South, and it was dispossessed anyway, which tells you that adopting the system was never the thing that would protect you inside it. Add the infrastructure. Ferries across the Tennessee, the Coosa and the Chattahoochee licensed and charging fares, grist mills and saw mills on the creeks, taverns and inns on the federal road, blacksmiths, orchards which matter enormously in a valuation because a bearing apple orchard represents 15 years of work and cannot be moved, fenced fields which represent thousands of hours of splitting rails. All of this was written down because the United States kept writing it down. Federal agents made periodic censuses of the southeastern nations, listing households, livestock, acreage under cultivation, looms and spinning wheels. When the removals came, those numbers were already on file in Washington. Nobody involved could claim not to know what was there. The value of it is the number the whole story turns on. The land alone, 7 million acres and more of it, was in country that was about to be some of the most productive cotton ground on earth. The improvements on top of the land, the houses and mills and ferries and orchards, were separately valued later at figures that ran into the millions on their own. And the Cherokee were not the only nation in the way. The Choctaw and Chickasaw held most of what is now Mississippi and western Alabama. The Creek held central Alabama. The Seminole held Florida. Between them, the 5 southeastern nations were sitting on the largest block of undeveloped cotton land in the United States at the exact moment. The price of cotton and the demand for it were both climbing. That is the commercial situation in 1828, and it is worth stating plainly because it explains the urgency. This was not a frontier dispute about grazing. It was a real estate problem with a national scale, and the people who understood it best were not the settlers. They were the land companies in New York and Mobile and Columbus, who were already organized, already capitalized, and already buying options on land that was not yet for sale. The legal assault opened in Georgia in December of 1828, and it was designed by lawyers. The state passed a series of acts extending Georgia law over the whole Cherokee territory and declaring the laws of the Cherokee Nation null and void from the 1st of June, 1830. It abolished the Cherokee courts. It forbade the nation's council from meeting. And it provided that no Cherokee could be a witness in any Georgia court in a case to which a white man was a party. Read that last clause again as a piece of economic engineering, because that is what it is. person who cannot testify cannot enforce a contract, cannot prosecute a trespass, cannot defend a title, and cannot resist an eviction. Georgia did not need to seize a single acre by force. It only had to remove the owners from the class of people whose word counts in a courtroom, and every asset they held became available to anyone willing to walk onto it. Andrew Jackson was inaugurated as president in March of 1829, and removal was the policy he had campaigned on. He had made his name and a great deal of his money in exactly this business, negotiating land cessions in Tennessee and Alabama over 20 years, and he did not regard it as a scandal. He regarded it as the obvious solution, and he said so in his first annual message. The Indian Removal Act came before Congress in the spring of 1830, and it is worth being precise about what it did and did not say. It did not order anybody to move. It authorized the president to negotiate treaties exchanging land in the East for land west of the Mississippi, and it appropriated $500,000 to do it with. On its face, it is a voluntary exchange program with a budget. The vote tells you what everybody understood it to mean. It passed the Senate comfortably. In the House, it passed by 102 votes to 97, a margin of 5, after weeks of debate in which the opposition argued, correctly, that no such exchange could be voluntary once a state had already abolished the other party's government. Very few pieces of American legislation, with consequences this large, have ever passed this narrowly. The Cherokee response was not a war, it was litigation, and this is the part that makes the story unusual. The nation hired William Wirt, a former Attorney General of the United States, one of the most expensive and most respected advocates in the country, and paid him out of national funds to sue the state of Georgia in the Supreme Court. The first case, Cherokee Nation against Georgia, was decided in 1831, and it lost on a technicality that has shaped American law ever since. Chief Justice John Marshall held that the Cherokee Nation was not a foreign state within the meaning of the Constitution, and so could not bring an original action in the Supreme Court. What it was instead, he wrote, was a domestic dependent nation, and its relation to the United States resembled that of a ward to his guardian. That phrase, ward and guardian, is doing something very specific. It denies sovereignty and asserts responsibility in the same breath. And a guardian, in the law of that time as in ours, manages the ward's property. The doctrine that would later be used to hold hundreds of millions of dollars of tribal money in federal trust accounts starts in that sentence. The second case, a year later, they won outright. Samuel Worcester was a missionary who had refused to take a Georgia loyalty oath and had been sentenced to 4 years of hard labor for it. In Worcester against Georgia, decided in 1832, Marshall held that the Cherokee Nation was a distinct community with its own territory in which the laws of Georgia had no force, and that the state's whole legislative program was unconstitutional. They had won in the highest court in the country, and it changed nothing. Georgia refused to appear, refused to acknowledge the judgment, and kept Worcester in prison. The federal executive did not enforce it. Jackson is supposed to have said that John Marshall had made his decision and could now enforce it himself, and it is worth saying clearly that there is no contemporary record of him saying it. It first appears in print decades later. He did not need to say it. He simply did not act, and not acting was sufficient. So the position by 1833 is this. The Supreme Court has ruled that the Cherokee Nation's territory is not subject to Georgia law. Georgia has surveyed that territory into lots and given them away by lottery. The federal government has declined to intervene. And a nation with a written constitution has just discovered that a judgment in its favor from the highest court in the land is worth precisely as much as the willingness of the executive to enforce it. What that means practically is that the Cherokee spent the next 3 years being dispossessed one household at a time by men holding lottery tickets. Lottery winners arrived and claimed houses that were occupied. The Georgia Guard was raised to police the territory and did so on behalf of the ticket holders. The Cherokee Phoenix had its press seized in 1834 and stopped printing. The Georgia Guard is the instrument that made all of it operational, and it is worth being clear about what it actually was. It was a state paramilitary force raised specifically to police the Cherokee territory, with authority to arrest, to seize property, and to remove people from land a ticket holder had claimed. It was not a court and did not need to be. A lottery winner with a certificate and a guard detachment behind him had to prove nothing, because the man in the house had no standing to make him. The press is the clearest single case of it. The Cherokee Phoenix was the nation's voice in English as well as Cherokee, and it was read in Boston and New York and Philadelphia, where a substantial body of opinion opposed removal and was being supplied with facts by it. In 1834, the Guard seized the press and the type. A newspaper that had been the most effective piece of political communication any native nation had ever run was silenced not by an argument but by the removal of a machine, and the removal of a machine is a property action. Elias Boudinot had already resigned as editor by then, over a disagreement with John Ross about whether the paper should be allowed to print the case for accepting removal. Ross said the nation's newspaper could not campaign for the nation's dissolution. Boudinot said a paper that could only print one position was not a newspaper. Both were arguing in good faith about a free press inside a nation fighting for its existence, and the disagreement would later kill one of them. And this is where the transaction takes the shape it keeps, because the pressure was not applied in order to force a surrender in the field. It was applied in order to produce a signature, and the whole of American treaty practice required a signature, because a treaty ratified by the Senate is title and nothing else is. The problem for the federal negotiators was that the man who could sign was not going to. John Ross, the principal chief of the Cherokee Nation, had been elected under the 1827 Constitution, held the confidence of the overwhelming majority of the nation, and had spent 6 years making the case in Washington that the nation would not sell at any price. He was a rich man in his own right and one of the ablest negotiators of his generation, and he did not move. So the negotiators found other people to sign. A small faction inside the nation had come to the conclusion that removal was now inevitable, and that the only rational course was to get the best terms available before the position collapsed entirely. They are usually called the Treaty Party, and their leaders were not marginal figures. Major Ridge was a Cherokee national hero. His son John Ridge was a lawyer educated in Connecticut. Elias Boudinot had edited the Phoenix. Their argument deserves to be stated at its strongest, because the story is worse if you pretend they were simply traitors. Their position was that the nation had already lost, that every month of delay meant more households evicted with no compensation at all, and that a negotiated price now was the only asset it could still realize. In the narrow commercial sense, they were right about the direction of travel. On the 29th of December, 1835, at New Echota, about 20 men signed a treaty ceding all Cherokee land east of the Mississippi to the United States. The Cherokee National Council had not authorized it. The principal chief was not present and had not agreed. The signatories held no office empowering them to convey the nation's territory, and they knew it. The price was $5 million, together with land in the Indian Territory west of Arkansas, an allowance for removal, and a subsistence payment for 1 year after arrival. For something over 7 million acres of the best remaining cotton land in the Southeast, plus every house, mill, ferry, orchard, and fence on it, $5 million works out at roughly 70 cents an acre before the improvements are counted at all. John Ross's response was to collect signatures. The protest document he brought to Washington carried something over 15,000 names against the treaty, out of a nation of perhaps 16 or 17,000 people. It is one of the most comprehensive expressions of opposition ever presented to the United States Senate on any question, and it is a genuinely extraordinary object, a petition signed by essentially an entire people. The Senate ratified the Treaty of New Echota in May of 1836 by one vote more than the two-thirds it needed. Senators who voted for it, including men who had spent years opposing removal, said openly in debate that the treaty was procedurally indefensible and that the alternative was worse. Ratified, it became the law of the United States, and the 15,000 signatures became a historical document with no legal effect whatsoever. The treaty gave the Cherokee 2 years to go. The deadline was the 23rd of May, 1838, and almost nobody moved, because almost nobody accepted that the treaty was theirs. That decision, taken collectively and in the belief that the United States could still be argued out of it, is why the removal happened the way it did rather than as an organized migration. There was one clause in the treaty that made a difference to a small number of people, and the way it worked is a property lesson on its own. Article 12 allowed individual Cherokee who wished to remain in the East to do so and become citizens of the states they lived in. In Georgia, it was worthless because Georgia had already resolved that question. In the mountains of North Carolina, it was not, because a group of Cherokee living along the Occonaluftee had been treated as separate from the nation for years. They still could not hold title. Land in North Carolina could be owned by a citizen, and their citizenship was exactly the thing nobody would confirm. So the land was bought for them by William Holland Thomas, a white trader who had been raised among them and adopted by their chief, and who purchased tract after tract in his own name with their money and held it. It was an arrangement with no legal protection at all, resting entirely on one man not defrauding several hundred people. He did not. Those purchases became the Qualla boundary, and the descendants of the people he bought it for are the Eastern Band of Cherokee Indians, who are still there. Several thousand people kept their place in the Southern Appalachians because a private individual was willing to act as a nominee, and for a century afterwards, the legal position of that land was a tangle that Congress had to resolve by statute. Ownership, when you are not permitted to own, comes down to whether somebody you trust is honest. Before the removal, though, there is the valuation, and the valuation is the part of this story that has almost never been told and is the most revealing thing in it. Because the treaty did not simply buy the land. It set up a commission to compensate individual Cherokee for their improvements, and that commission worked the way any compensation scheme works. People filed claims. Assessors went out and looked. Values were written in a column. So there exist in the National Archives schedules listing what each household lost, item by item, in the handwriting of federal clerks. A dwelling house, so many feet by so many of hewn logs with a plank floor, so many acres under fence, a peach orchard of so many trees, a grist mill with an overshot wheel, a ferry with 2 boats and the right to charge. Look at that as an accounting document rather than a historical one, and something jumps out. The United States government produced, at its own expense, a detailed and reasonably careful inventory of the property of the people it was removing. It valued a ferry as a going concern. It valued fruit trees by age. It was not pretending the property did not exist. It was pricing it. And the awards were real. Money was appropriated and money was paid. But 3 things happened to it on the way, and each of them is a mechanism worth knowing because each of them turns up again in every later dealing of this kind. The first is that the valuations were made under conditions that guaranteed they would be low. A man being valued for a house he is about to be removed from has no alternative buyer, no ability to hold out for a better price, and in Georgia, no standing to sue if he thinks the assessor is wrong. There is no market. There is only an assessor with a schedule. The second is that debts were deducted. Claims against Cherokee individuals by white traders and merchants were presented against the awards and taken out at the top, and the volume of claims that suddenly materialized in the years when a fund of $5 million was known to be coming was, to put it at its mildest, remarkable. The third is the one that changes the whole character of the transaction. The costs of the removal itself, the wagons, the rations, the contractors, the steamboat charters, the soldiers' provisions, were charged against the $5 million. The purchase price was not $5 million net. It was $5 million gross, less the cost of the operation carried out against the sellers. Sit with that for a second, because it is the sentence that should survive this video. The Cherokee Nation paid for its own removal out of the money it was given for its land, and the accounting was done openly, in ledgers, by clerks who saw nothing unusual in it, because within the logic of the transaction there was nothing unusual in it. Removal was a cost of acquiring the asset, and the asset had been bought with a fund, so the cost came out of the fund. The removal itself has been described 1,000 times, and I am not going to describe it again in detail, because it is not what this channel is for. The essentials are these. In May of 1838, with the deadline passed, General Winfield Scott was sent in with an army of regulars and militia, and about 16,000 Cherokee were collected into camps over the summer. The summer was hot, the camps were crowded, the water was bad, and disease moved through them. Scott had planned to send everybody west immediately by river. John Ross went to him and argued that the nation should conduct its own removal instead, overland, in organized detachments led by its own people, starting in the autumn when the weather had broken. Scott agreed. That agreement is why the money and the suffering are the same subject. Ross contracted to move the nation at an agreed rate per person, and the figure negotiated was around $65.88 a head, covering rations, wagons, teams, and the whole apparatus of moving 13,000 people 1,200 miles in winter. It was, by the standards of government contracting, not an unreasonable rate. 13 detachments went west between October of 1838 and March of 1839, on several routes, through an unusually severe winter. Rivers froze and detachments waited on the banks for weeks. The number of deaths is the most argued-over figure in the whole subject. The estimate that has stuck is 4,000, made by an ethnographer late in the 19th century, and modern historians have put it both higher and lower without settling it. One thing before we go on. If you subscribe, it genuinely helps this channel keep going, and there is a new piece of American financial history every single day. When it was over, the bill was presented, and the Cherokee Nation and the United States went to war over it in the only forum left, which was accounting. Ross submitted the costs. The War Department disallowed a substantial part of them as excessive. The dispute over the removal accounts ran for years, was referred to commissions, went back to Congress repeatedly, and produced a paper trail thicker than the treaty itself. Think about the position that puts the nation in. It has been removed from its land under a treaty it did not sign, at a cost deducted from the price it did not agree, and it is now in a commercial dispute with the buyer about whether the removal was carried out efficiently enough to justify the deduction. There is no more complete description of what happened than that sentence. The rest of the $5 million went the way the rest of such funds went. It was held by the United States as trustee for the nation, invested in interest-bearing securities, and paid out in annuities. The guardian relationship John Marshall had described in 1831 had become a literal fiduciary one, with a ledger, and the beneficiary had no power to audit it. And there was one more account to settle, which the nation settled itself. The Cherokee had passed a law in 1829, making it a capital offense to sell national land without the authority of the National Council. It was not an obscure statute. It had been written precisely because the nation could see what was coming and understood that its greatest vulnerability was not an army but a signature. Everyone who signed at New Echota knew about it, and Major Ridge is recorded as having said as much on the day. On the 22nd of June, 1839, a few months after the last detachments arrived in the West, Major Ridge, John Ridge and Elias Boudinot were killed on the same morning, in 3 separate places, by men acting under that law. Stan Wadey, who had also signed, was warned in time and lived. The nation had been removed 1,200 miles, had buried an appalling number of its people on the way, and the first thing that happened when it arrived was that it enforced its own property statute. You can read that as vengeance, and plenty of people did. But the law it was done under was a law about title, and the offense it punished was conveying an asset you did not own. In the West, it split the nation into factions that were still fighting each other 20 years later, and when the American Civil War came, the Cherokee fought it on both sides, along the same line. A dispute about who had authority to sign a deed produced a civil war inside a nation that had already lost the land. Now widen the frame, because the Cherokee case is the famous one, but it is not the largest, and the other 4 nations show you the mechanisms with different variations. Between 1830 and 1850, the removals moved somewhere around 60,000 people and transferred something in the region of 25 million acres. The Cherokee cession is under a third of it. The Choctaw went first, under the Treaty of Dancing Rabbit Creek in 1830, and their treaty contained a clause that looks like a protection and functioned as a trap. Article 14 provided that any Choctaw who wished to stay in Mississippi could do so, and would receive an allotment of land in fee simple, becoming a citizen of the state. Thousands wanted to take it. Registering was the whole thing, and the agent responsible for registering them, William Ward, did not register them. Claims were refused, applications were not recorded, and the register was kept in a way that produced almost no valid entries. The great majority of the Choctaw who had chosen to stay and become landowners under the treaty found afterwards that in the paperwork they had never applied. Their land was sold. The litigation over the Article 14 claims went on for the rest of the century. The Creek Treaty of 1832 did the opposite and produced a worse outcome. It allotted land directly to Creek heads of family in individual tracts that they could sell, and by allowing the sale it created, overnight, several thousand illiterate sellers, no legal protection worth the name, and a large and well-organized body of buyers who had been waiting years for exactly this. What followed is known as the Creek Frauds, and it is documented because the federal government investigated it and the report survives. Speculators bought allotments with impersonators standing in for the true owner. Deeds were signed by people who had no title. Certifying officials were paid. Whole tracts were conveyed for a few dollars and a barrel of whiskey, resold within days at many times the price, and the profits were real and large. Within about 2 years, the majority of the Creek allotments were in the hands of land companies. The Columbus and the New York and Mississippi land companies and their competitors had turned a treaty designed to leave the Creek as landowners into a mechanism for acquiring their land at a discount, and a speed no ordinary purchase could have achieved. The Creek, who had been allotted land, and who now had neither land nor money, were removed anyway in 1836. The Chickasaw are the exception that proves the thesis, and their case is the one an accountant should look at hardest. Under the Treaty of Pontotoc in 1832, the Chickasaw did not accept a lump sum. They insisted that their land be surveyed and sold at public auction by the United States as their agent, with the proceeds credited to them. They were, in effect, the only nation that sold its land on the open market. And it worked up to a point. The Chickasaw land fetched something in the region of $3 million, considerably more per acre than the negotiated cessions, and the Chickasaw paid for their own removal out of it as a matter of deliberate choice rather than imposition, which put them in a materially better position on arrival than any of their neighbors. That difference is entirely attributable to the auction clause. Then the money was held for them, and the trusteeship did what trusteeships did. The fund was invested by the federal government in state bonds, and in the years around 1840, a number of American states defaulted on their debt. Tribal trust funds took losses on those holdings that the beneficiaries had no say in incurring and limited means of recovering. Selling at the right price turned out to protect you only until the proceeds entered somebody else's accounting system. The Seminole refused, and the arithmetic of what that cost the United States is the sharpest number in this entire subject. The Second Seminole War ran from 1835 to 1842. The cost to the federal government is usually put somewhere between $20 and $40 million, with $30 million the figure most often quoted. Around 1,500 American soldiers died, most of them of disease. Set that against the $5 million paid for the Cherokee cession. The United States spent something like 6 times as much fighting one nation that would not leave Florida as it paid to acquire the entire Cherokee territory in Georgia, Tennessee, Alabama, and North Carolina. The war was not economically rational by any measure available at the time or since. It was fought because the policy could not be seen to fail, which is the most expensive reason any government ever does anything. So what did the land do afterwards? Because that is the question that makes the whole exercise legible. The removals were not the end of a story about a frontier. They were the beginning of a story about cotton. The land opened by the removals in Mississippi, Alabama, and Georgia became, within a decade, the most productive cotton country in the world. The Black Belt filled up. Cotton production in the United States roughly tripled between the early 1830s and the 1850s, and the greatest part of the increase came off the ground the 5 nations had held. And cotton on that scale was worked by enslaved people. So the same transaction that moved 60,000 people west also moved an enormous number of enslaved people south and west into the new districts. In the domestic trade that carried perhaps 1 million people out of the Upper South between 1820 and 1860. The removals and the expansion of slavery are not 2 adjacent subjects. They are one operation with 2 sets of victims and 1 balance sheet. The people who did best out of it were not the lottery winners, most of whom sold their tickets or their lots within a year or 2 to men with capital and went back to what they had been doing. It was the land companies, the banks that lent against the new cotton land, and the merchants who financed the crop. A lottery distributes land widely and briefly. The market concentrates it, and it did. The federal government did well too, and this is the part that closes the circle. Public land sales were one of the largest sources of federal revenue in the 1830s, and in 1836, the receipts were so enormous that the Treasury ran a surplus it did not know what to do with and distributed it to the states. The land the government had acquired at 70 cents an acre it was reselling at $1.25, and the volume of it briefly wiped out the national debt. And then it all fell over, which is the part of the story the people who profited did not see coming. The land boom of the 1830s was financed on credit, in banknotes issued by state banks against land that had just been bought with more banknotes. In July of 1836, the Treasury issued the Specie Circular, requiring gold or silver for purchases of public land, and the whole structure came down. The Panic of 1837 wiped out banks, land companies, and speculators across the South and West, and a great many of the men who had acquired Creek allotments and Cherokee lots at a discount were ruined inside 2 years. That undoes nothing, and it is not offered as consolation. It is the pattern. The people who take an asset cheaply in a boom are rarely the people who end up holding it. The land went through bankruptcy and foreclosure into the hands of whoever had cash in 1842 and produced cotton for them exactly as it would have for anybody. A transfer of this kind does not enrich the people who carry it out. It enriches whoever is solvent at the end of the decade. In the West, meanwhile, the Cherokee Nation did what it had done before. It adopted a new constitution in 1839, rebuilt its council, and by the 1850s was running a school system that was, by several measures, better funded and more effective than those of the neighboring states. It was a functioning republic again, inside 15 years of the worst thing that had ever happened to it. And it was dissolved again. The Curtis Act of 1898 abolished tribal courts and governments in Indian Territory. Allotment broke up the communal holdings, and in 1907, the territory became Oklahoma. The nation removed to make way for a state was removed a second time to make way for another, by legislation rather than treaty, and the machinery was allotment, which is to say private title. That is the ledger then, and it is worth reading in one line. Roughly 25 million acres acquired. About $5 million paid for the largest single cession, less the cost of the removal, less the debts deducted, with the remainder held in trust and invested by the buyer. One war costing 6 times the purchase price of the thing it was about, and a national debt paid off out of the resale. The legal residue outlasted everybody. The guardian relationship became the trust doctrine, and the trust doctrine meant the United States held and invested tribal money for 150 years, with an accounting that was finally challenged in the courts in the 1990s. That case over the government's management of individual Indian trust accounts ran for more than a decade and was settled in 2009 for $3.4 billion, on the basis that the records were in such a state that the true figure could not be established. The allotment policy came back in 1887 with the Dawes Act, on the same theory that individual title would protect people better than collective title, and it produced the same result as the Creek allotments had, only across the whole country and at a far larger scale. Tribal land holdings fell from about 138 million acres to about 48 million in under 50 years, and most of the loss went through legal sales. So, was it a taking? My own answer is that the question is asked the wrong way round, and the lottery is what shows you why. Georgia did not seize the Cherokee Nation and then find a legal justification. It surveyed the land, numbered the lots, drew them out of a wheel, and issued certificates of title to private citizens. And only afterwards did the federal treaty arrive to make those certificates good. The paperwork did not follow the taking. The paperwork went first, and the taking was the enforcement of it. That is what makes this a story about property law rather than about conquest. A conquest ends when the fighting stops and can be reversed by the next war. A title recorded in a state register, drawn in a public lottery, confirmed by a treaty the Senate ratified and priced by a commission that paid awards, does not need to be defended again. It sits in the chain of title, and every subsequent sale relies on it, and after 2 or 3 transfers the question of how it started stops being a legal question at all and becomes a historical one, which is exactly what was intended and exactly what happened. There is not a single acre of that ground today whose deeds do not run back through the 1832 lottery to a grant made by a state to a man who drew a number out of a wheel. The number is still there in the record. It is what the land is called.